You know that feeling when you're doom scrolling? It's like 2 in the morning, you're deep in some comment section, maybe arguing with a total stranger about something, and you just think, if I could just find the right words, the perfect phrase, I could fix this.
The universal fantasy.
Yeah.
The cheat code for reality.
Exactly. It's like we all sort of believe that if we just stare into a mirror and say the right thing 3 times, all the problems will just vanish. And nowhere, I mean, absolutely nowhere, is this feeling stronger than in the legal world.
Oh, absolutely. It's a very specific kind of folklore.
If you've spent any time on, legal Twitter or some of the weirder Facebook groups, you've definitely seen it. There's this idea that statutes, I mean, literal laws passed by the government, can just be undone by invoking the name of a court case, like it's a spell.
As if you could just shout, Marbury v. Madison, and the police officer just, tears up your speeding ticket?
Right. But if that actually worked, Tallahassee would be a very, very quiet place. And frankly, a lot of lawyers would be out of a job. But as we're going to find out today, the law is not Beetlejuice.
It is not Beetlejuice. It is, unfortunately, much more boring and much more rigid than that.
But today's going to be fun because we aren't just reading, dry legal texts. We're diving into a set of sources that frame this whole discussion through a really funny satirical character. The source calls him Trevor.
Ah, yes. Trevor. We all know a Trevor.
We do. So let's paint a picture of Trevor for you. He's the guy who fancies himself a high-powered attorney. But here's the catch. He has absolutely zero legal training, never set foot in a law school, doesn't have a bar card.
But he probably has a premium ChatGPT account.
Oh, he has a ChatGPT account, a very loud keyboard, and just supreme confidence. And Trevor's main belief, the thing we're going to dismantle today, is that case names are basically magic incantations.
He thinks they're talismans.
Exactly.
Mm-hmm.
He believes if he just shouts Kluger, which is a specific case we'll get into, if he shouts it loud enough, the statutes he hates will just, poof, vanish.
It's magical thinking. It's, it's comforting, but it's completely wrong.
So here is our mission for this deep dive. We're going to take Trevor's misunderstandings and use them to explain how the law actually works. We're going to look at the unglamorous mechanics of how a statute dies, why there's a huge difference between abolishing a right and just regulating it, and why getting this wrong matters for everyone.
And honestly, this isn't just for the legal eagles. This is for anyone who has ever seen a viral post declaring a law unconstitutional and wondered, okay, so if it's unconstitutional, why is it still in the books?
This is the Blinkist version of Con Law 101. So let's start with the basics, the unglamorous mechanics, as our notes call them. Trevor's convinced he can kill a statute with, a sternly worded email. What's the cold, hard reality here?
It is so much simpler and so much harder than Trevor thinks. In Florida, a statute ends in exactly 2 ways. That's it, 2.
Okay, lay them on me. What's option 1?
Option 1, the legislature repeals it or amends it. This is the democratic way. They go back into the chamber, they debate, they lobby, they vote, and they change the text of the law itself.
Okay, so that's the standard schoolhouse rock method.
Correct. And option 2, a court, in a proper case with actual parties, real people suing each other, looks at the law, says this is unconstitutional, and enjoins it.
Enjoins it. Okay, let's pause on that word. That's a legal term.
Right. It basically means the court puts up a stop sign. An injunction is a court order that says to the government, you must stop enforcing this law.
So repeal or injunction, those are the 2 paths. But notice what's not on that list.
Right. Press conferences are not on the list. Viral tweets, letter writing campaigns, sternly worded notices of noncompliance sent by, sovereign citizens.
So you're saying I can't just post a law out of existence. If I get 1 million likes on my rant, it doesn't just legally disappear.
You cannot. And this is where people get really, really confused. Those things, the protests, the tweets, they're politics. And they're vital for politics. They can shift public opinion. They can pressure the legislature to do option 1. But they do not themselves erase text from the Florida statutes.
There's a great line in our source material about this. It says, if shouting void ab initio worked like a magic word, every lobby in town would be doing it.
It's a hilarious image. Just imagine lobbyists on Monroe Street in Tallahassee just shouting Latin phrases at the Capitol, hoping the law books inside just rewrite themselves.
It would be total chaos. You'd have people shouting habeas corpus just to see what happens.
It would be. But there's a serious point here. A judge cannot read your Facebook posts into the Florida reports. Legal authority comes from very specific sources. Everything else is just noise. It might be loud noise, it might be righteous noise, but legally, it's just noise.
Which brings us to the specific noise Trevor is making. He has a favorite magic spell. It's a case called Kluger v. White.
Ah, Kluger. The famous Kluger.
Trevor seems to think Kluger is this all-powerful talisman. He thinks if he just waves Kluger at a law he doesn't like, the law has to disappear. But the sources suggest he's using a hammer to turn a screw.
This is the absolute core of the confusion. Trevor sees Kluger as a talisman, like you said, a magic object that wards off evil. If a law is bad, Kluger kills it. But in reality, Kluger is a trigger, and it is a very, very specific trigger.
A trigger for what?
It triggers only when the legislature abolishes a cause of action that existed before 1968.
Okay, abolishes a cause of action. Let's decode that. Cause of action is just lawyer speak for the right to sue, isn't it?
Correct. It's your ticket to the courthouse. If I have a cause of action for negligence, I have the right to file a lawsuit and ask for damages. Kluger says the legislature can't just slam the courthouse door in your face for something you used to be able to sue for, unless they give you a reasonable alternative.
So it's about access. It's about keeping the door open.
Precisely. It's about total abolition. The Constitution is saying you can't just delete a legal right without replacing it with something.
So let's apply this to the specific law that drives Trevor nuts. We're talking about Section 768.2188. It deals with wrongful death and medical negligence. What does it actually do?
It's a limitation on damages. Specifically, it limits who can recover which non-economic damages, things like pain and suffering. It says, essentially, if the victim was an adult child over 25, the parents can't get money for their pain and suffering.
Okay, so Trevor looks at this limit, this restriction on getting that money, and he screams, abolition, Kluger, void.
Exactly. He sees a restriction, and he calls it an abolition. But he's wrong, because that section sits inside a wrongful death scheme that still exists. The cause of action is still there.
Meaning the lawsuit can still happen.
Yes. The estate still sues the doctor. They still litigate for economic damages, lost wages, medical bills, funeral expenses. The trial happens. The jury hears the case. A verdict is read.
So the courthouse door isn't locked.
No, the door is wide open, and that is why Kluger simply doesn't apply. The source uses this fantastic analogy that I think just clears it up instantly.
The road analogy, I love this one.
Yes. Calling this damage limit an abolition is like calling a speed bump a road closure.
Okay, let's unpack that,
It
because
go-
they both slow you down.
They do. But imagine you're driving. A road closure means you cannot pass. There's a concrete barrier. You can't get to your destination. That is abolition. That is what Kluger prevents. It stops the state from barricading the road to the courthouse.
What a speed bump.
A speed bump is annoying. You might hate it. You might think it's just terrible policy. It restricts how fast you can go. But, and this is the key, the road is still open. You can still drive down it. You just have to deal with the restriction.
So Kluger protects against road closures, not speed bumps.
Exactly. Kluger protects against locking the courthouse doors, not against moving the furniture around once you're inside. Because the cause of action, the right to sue, isn't abolished, that substitute remedy requirement from Kluger is never even triggered. The gun doesn't go off.
That makes so much sense. So Trevor is just standing at a speed bump screaming that the road is closed.
He is. And to the people driving by, the judges and the lawyers who know the rules, he looks, well, ridiculous.
But here's where I want to push back a little, because I think I can hear the audience asking this. Let's say the speed bump is huge. Let's say the cap on damages is so severe it feels unfair. If Kluger is the wrong tool, if it's the wrong magic spell, does that mean there is no tool?
Not at all. And that's the tragedy of Trevor. He's so focused on the wrong tool, he's ignoring the one that actually works. Lawyers do challenge these caps, and sometimes they win.
So what's the right tool? If I want to fight a speed bump, what do I use?
If you want to challenge damage caps in Florida, the proper constitutional lens is not access to courts under Kluger, it's equal protection.
Equal protection.
Yes, you look at cases like McCall and Calatin, these are the heavy hitters for this kind of argument. And the test under equal protection isn't, did you abolish a right? The test is about arbitrariness and empirical fit.
Arbitrariness and empirical fit. That sounds much more scientific than magic spell.
It is. It asks, do the lines the legislature drew actually make sense? And do those lines fit the evidence?
Can you give me an example? How would you prove a law is arbitrary?
Okay, so suppose the legislature says, we need to cap damages to lower medical malpractice insurance rates. That's the goal. Under equal protection, the court looks at the actual data. If the evidence shows that capping damages doesn't lower insurance rates, then the law might fail the test. It's arbitrary. It treats people differently for no rational reason.
I see. So Kluger is a sledgehammer. You close the road. Equal protection is more like a socket wrench. Does this specific part fit the machine correctly?
That is a perfect way to put it. Kluger is blunt force. It's for smashing an abolition. Equal protection is nuanced. It's for checking if the specific parts, the caps, the limits, fit the constitutional design.
And you can't use a sledgehammer to turn a bolt.
You cannot. Or, I mean, you can try, but you're just going to break the window and scream at the wall.
Which brings us right back to Trevor. He's banging on the wall with a sledgehammer, shouting magic words, while the actual lawyers are quietly using a socket wrench to take the engine apart.
That's exactly it. You can oppose caps, many smart people do, but you have to use the right doctrinal toolbox. You have to argue that the classification is arbitrary, not that the right's been abolished.
Now, speaking of arbitrary, Trevor has another obsession I found really interesting. He seems to think that if a law was passed, say, 36 years ago, he can invalidate it by playing archaeologist with old staff memos.
Ah, yes. The 1990 findings myth.
Walk us through this. Trevor believes that if some staff memo from 1990 doesn't say insurance crisis 12 times, then the current law is invalid.
This is a classic example of confusing legislative history with legislative power. Trevor thinks the validity of a law depends on what some staffer typed up in a report 3 decades ago.
And the reality?
The reality is that Florida courts do not require formal crisis findings for ordinary policy choices. A statute can be upheld on any rational basis.
Any rational basis, even if they didn't write it down at the time.
Yes, even one that wasn't written in a memo. The court looks at the statute now. Does it make sense today? Is there a rational reason for it? They don't look at a dusty memo from 1990 and say, oh, well, Steve the staffer didn't type the word crisis on page 7, so the whole law is void.
That's a funny image. Steve the staffer holding the weight of the Constitution in his typo-filled memo.
It's just incredibly shaky ground. As the source says, building a constitutional argument on what a staffer didn't type decades ago is like pouring the foundation on a Post-it note.
It just doesn't hold up.
No.
Yeah.
Legislative history is helpful context, sure. It can help us understand what they were thinking. But it's not handcuffs. The enacted text is what controls.
There's one more phrase Trevor loves to throw around, and it sounds very serious. Justice shall be administered without sale, denial, or delay.
Yes, from the Florida Constitution, Article 1, Section 21, a very important provision. And Trevor latches onto the words, without sale.
Right. He argues that if you cap damages, if you say you can only get this much money, that you're selling justice. You're putting a price tag on it.
This is a common rhetorical move. It sounds good on a bumper sticker. But legally, it fails. The without sale provision has a very specific historical meaning. It literally means you can't bribe the judge.
Oh, literally buying the verdict.
Right. Or it means the court can't charge you some exorbitant fee just to get in the door. It's about access fees. It is not about the outcome of the case.
So limiting the payout isn't the same as charging an entry fee.
Correct. A cap is a policy trade-off. It is not a literal sale of justice. A cap is not a cash register at the courthouse door.
So to go back to our analogies.
If the courthouse has a turnstile where you have to put in a gold coin to enter, that is a sale problem. That's unconstitutional. But if the road to the courthouse has a posted speed limit, a cap, that's just regulation.
I really hope our listeners are visualizing this. Turnstiles versus speed limits. Sledgehammers versus socket wrenches. It really clarifies why just shouting unconstitutional doesn't work.
It's all about the right tool for the job.
I want to zoom out a bit here. We've been talking about the mechanics, the how. We've bashed Trevor a bit for his magical thinking. But let's talk about the why. Why does he care so much? Why do we care? Ultimately, this isn't just a word game. This is about people getting hurt and seeking justice.
It is. And this is where we move from the technical to the philosophical. The source brings up a really profound distinction between money and accountability.
Break that down for us, because usually in a lawsuit, money is the accountability. That's how we measure it.
That's how we usually think of it. Money compensates for harm. If you're injured, money pays your medical bills, covers lost wages, tries to make up for your pain. That is vital. But accountability, true accountability, prevents the next harm from happening.
That's a huge distinction.
It is. And the argument here is that if we have a system that focuses solely on the size of the check, but ignores system fixes, we've failed.
What do you mean by system fixes?
I mean, things like early disclosure of medical errors, honest audits when things go wrong at a hospital, sanctions for bad actors. If you just fight about the cap, should the check be $500,000 or $1 million, but you don't change the safety protocols that led to the mistake, what happens?
You get another lawsuit next year.
Exactly. You get better verdicts and the same mistakes.
Wow. Better verdicts and the same mistakes. That hits hard. It feels like we're just running on a hamster wheel.
It should. There's a quote here that I think every listener should just carry with them. A system that prefers larger checks to fewer funerals has confused remedy with justice.
That is powerful. Confused remedy with justice.
Right.
Because the remedy is the money. That helps the family after the tragedy. But justice would be the person not dying in the first place.
Precisely. And that's why Trevor's obsession with magic words is actually kind of tragic. He's looking for a spell to make the bad law go away so he can get the big check.
Yeah.
But he's missing the actual work of analyzing the system. That is hard work. It's not magic.
It really highlights the difference between being a keyboard warrior who just wants to win the argument and actually understanding the purpose of the law. Trevor wants the quick fix.
But the law doesn't work on quick fixes. It works on process. It works on structure, on precedent.
So let's recap the lessons from Trevor. If you're listening and you want to be smarter than the guy shouting in the comments, what are the 3 big takeaways?
Lesson 1, process reality. Statutes do not end because you wrote a stern letter or got 1,000 retweets. They end by legislative repeal or a court judgment. Period.
Got it. No magic erasers.
Lesson 2, doctrinal fit. Know your tools. Kluger is for abolition road closures. Equal protection is for caps and limit speed bumps. Don't bring a sledgehammer to a socket wrench fight.
In lesson 3.
Context. The enacted text of the law controls, not some 36-year-old staff memo. Courts review the statute for constitutional fit today, not for the editorial prose of a staffer from 1990.
It really all just comes down to using the right tool. It's almost comforting in a way to know that the law isn't magic, it's logic, it's a machine.
It is. It's accessible if you stop looking for the trapdoor and start looking at the blueprints. Law is not Beetlejuice. You can't just say a case name 3 times and expect the legislature to disappear.
And thank goodness for that. Imagine if we could repeal speed limits just by shouting Marbury v. Madison out the car window.
The commute would be terrifying. I wouldn't leave the house.
It really would. You know, this leaves me with a lingering thought. We spend so much time looking for the gotcha, the magic spell that fixes a problem instantly, in law, in politics, even our personal lives. But maybe the question we need to ask ourselves is, are we looking for a magic spell, or are we willing to do the actual work of analyzing the system?
That is the question. The work is harder, but it's the only thing that actually builds a better road.
Well said. That's it for this deep dive. No magic spells here, just a little more clarity on how the machine actually works. Thanks for listening.
Statutes don't vanish by incantation. Repeal, judgment, or nothing.
See you next time.